Ghana is interesting. Memamoti say, just as the petition to President Akufo-Addo, you can say only a year Chief Justice Gertrude a year Tokonu a won you no. On say sa petition no leaky. You can say sa petition we are asanso abeyi. Sa new petition ya abeyi. 3 petitions here nam so nti ya form a year prima facie case no. Me can say enye me wan say petitions no ebe leaky. And the documents be about bontin ya say the alleged petition of one of the group inti nkrofo miensa na petition inti emu baako the petition in a leaky. Now I would want us to go through the petition and see the things and nkrofo no aka enu nti almost say president engineer so na yempami chief justice president ne trese prima facie case na trese ensem wa yesi won gina so no ensem bia we hu ne say edimu. Inti this alleged petition was sent to the president on 14 February 2025. Just say Val's Day. Hey, inti Valentine's Day pam ye sure say na mami one ni kunu ene nebusuafo eji omweni no obi I send the petition akwa koma president say yin mami free ho. On the 14th February 2025, His Excellency the President of the Republic of Ghana, Flagstaff House, Accra. I say, dear Mr. President, I say petition for the removal of the Chief Justice of the Republic of Ghana, Her Ladyship Gertrude Saki Tokonu. Preamble. I say, we the Shining Stars of Ghana, citizens into group needing no Shining Stars of Ghana. So that's the name of a yekuo and more petition president. They call the Shining Stars of Ghana. I say, we the Shining Stars of Ghana, citizens of the Republic of Ghana, humbly submit our petition to Your Excellency, the President of the Republic of Ghana, praying for the removal of Her Ladyship Gertrude Saki Tokonu, the Chief Justice of the Republic of Ghana. Our petition is initiated as a result of the Chief Justice's demonstration of 1. I. Stated misbehavior. I. Incompetence. It's almost a Chief Justice now you see yenyi no omo ekune from the Shining Stars of Ghana no. Yenyi Chief Justice because 1. Wendi ne huni. 2. Wa trese ejuma no ontumi nye. It's 2 reasons ntia wo mo see yenyi no. Now it's a legal basis of our petition. I say legally our petition is grounded on Article 1461 of the 1992 Constitution. We've all read Article 1461 and we know what it talks about, right? So I don't want to go deep into that. I mean, Article 1461, we've talked about it on this platform. I've read the whole article, the entire article on both of my platforms. What I say, but let's jump forward because petition is quite lengthy. As a meaning of stated misbehavior, and what trust you say, you can say misbehavior as a trend saying, Natiha, according to Black's Law Dictionary, revised 4th edition, 1968, misbehavior means conduct, improper or unlawful behavior. Say Chief Justice we any the past Chief Justice. And someone omo NDC for in some way go Supreme Court. Almost say according to Black Dictionary, it is Black Dictionary ya Black's Law Dictionary ya na nkrofo so eyusu atrese omo tre the meaning of misbehavior. I say again, with reference to Cambridge Advanced Learners Dictionary, misbehavior means bad behavior. And you know, the first grounds are almost misbehavior. No misbehavior no as a trend saying not just any pakro no saying American we mdi ni huni. Inti no eno mo tremu. Ewo law afemu. Now the meaning of incompetence. Or say although incompetence is not explicitly defined in the 1992 Constitution of the Republic of Ghana, its meaning is explained by some authorities. Reference from Cambridge Advanced Learners Dictionary indicated that incompetence is lack of ability to do something successfully or as it should be done. Into no omotre incompetence. Ye kaso bi eye incompetent a ye kan wo twi mu na wate ase a trese nipa kro no wa bon. Si ye obi incompetent a simply that's what it means. Wa bon. Ejuma no ntumi nye. Nti no mo kan. Or say course of action of our petition. The entire wo mo take petition we. Or say act of stated misbehavior by the Chief Justice. The Chief Justice in nyama awaye a ye trese no hunti trese wendi ni huni nti no yini free hono. I say on 30th May 2024, the Chief Justice of the Republic of Ghana officially wrote a proposal to the then president Nana Addo Dankwa Akufo-Addo to appoint 5 judges to the Supreme Court. In her proposal, she added that I write to respectfully request that the following judges be appointed to the Supreme Court of Ghana. You know, that assembly Chief Justice no trauma President Akufo-Addo. Eka say 1-4 emra meka ne ho e wo Supreme Court no. Or say the above action taken by the Chief Justice was in breach of Article 144 of the 1992 Constitution of Ghana. It is pertinent to cite the entire provision of Article 144 at this moment. They thus read. Into what I say Chief Justice no catch President Akufo-Addo say, "Wonfa nkrofo bi mra meka ne ho wo Supreme Court no. Chief Justice no wetia mra. Mra na wetia na ye Article 144. Into omo kenkan Article 144 na Ghana for yati ase. Article 144 nini. Or say the Chief Justice shall be appointed by the President, acting in consultation with the Council of State and with the approval of Parliament. 1442. The other Supreme Court justices shall be appointed by the President, acting on the advice of the Judicial Council in consultation with the Council of State and with the approval of Parliament. 1443. Justices of the Court of Appeal and of the High Court and chairmen of regional tribunals shall be appointed by the President, acting on the advice of Judicial Council. 1444. Panel members of the regional tribunals other than the chairman shall be appointed by the Chief Justice in consultation with the Regional Coordinating Council for the region and on the advice of the Judicial Council. Or say a cursory look at Article 144 clearly indicates that the Chief Justice is not mandated by any provision to officially make a request to the President regarding appointment of justices to the Supreme Court. We read the Article 144 talking about the appointment of justices to the Supreme Court and the Appeals Court. And then the regional tribunals. What I say, Nini Nemuno, in none of these articles, any can say, Chief Justice now say will request it, just as the Chief Justice wrote, say, I request to you the President, no. Or say, in none of the articles, in none of the law, and can't say Chief Justice whom they also request it, Emma President, said in Krofoba Supreme Court, Emma no. Inti Abanesena and the Chief Justice no go to me request Emma President Akufo-Addo say, one for judges being mekan who Supreme Court or. Clearly, no, with Yamra. Or say clearly, the action taken by the Chief Justice breaches Article 144 of the 1992 Constitution of the Republic of Ghana and meets the threshold of stated misbehavior. Hence, our humble prayer that Her Ladyship, the Chief Justice of Ghana, is removed from office to restore some dignity and public confidence at that high office. And I think that at this point, on my first point I will make it is clear. So Chief Justice Nadia Woye, you know, etiambra. You see, and sometimes I want people to understand. Sometimes, even in this petition, no, they didn't really go into details the meaning of things like this. Now, if you are to have a very partisan Chief Justice, and then the Chief Justice is able to request, assume a senior bentin among for Mumbra Supreme Court, and Mamia. You see, there are a lot of dealings a bit to me. If you have a very partisan or corrupt Chief Justice, for all you know, no, yes, any yejiji sikania de nkrofo Supreme Court. And I say, omo yedi omo Supreme Court no kra no. Ye to omo allegiance. Because mind you say it is the Chief Justice who empanels judges to a case. It is so no edi nkrofo aba Supreme Court. Na case bi aba no wo interest wo mu a. Guess what is going to happen? Guess what is happening to our judiciary? Or the nkrofo na wo de omo aba na wo mu owe allegiance to wo no and e beti na case ni so. Then at the end of the day, instead of fairness, it was ye didi asem ne yemfa nkonkodi. Na asem na ba be ye bubruja. So it is entirely wrong that a Chief Justice will request say say fan crofo bra hama me fan da bi into constitution him no anka. So basically the Chief Justice sadia na wo ye no entwa ye. Or say act of incompetence by the Chief Justice. Or say 9. On 15th October 2024, Honorable Alexander Afenyo Markin invoked the original jurisdiction of the Supreme Court under Article 210B of the 1992 Constitution of the Republic of Ghana. The plaintiff's invocation was activated by a dispute surrounding the filing of nominations by some members of Parliament intended to contest the impending December 7, 2024 general elections, either under the ticket of different parties or as independent candidates. Or say, among the issues set down by the plaintiff for determination, emphasis on on issue 7 of the purpose of this petition is whether or not the Speaker of Parliament was in breach of the rules of natural justice, that is, odi alteram partem rule, in declaring these 4 parliamentary seats vacant without giving the 4 affected members of Parliament a hearing. Into the second case, almost say the Jinaso into President Afenyo Chief Justice, the very popular and controversial Afenyo Markin versus Abambagbin case. Now, was it in our opinion, the Chief Justice who presided over the suit to determine whether or not Speaker of Parliament was in breach of the rules of natural justice, rather breached same rules in the process of making such determination, which amounts to incompetence. Or say Afenyo Markin eden sem ekoto Chief Justice enim na Supreme Court enim. Na Afenyo Markin asem a wode baaye no, de na wo kan say Supreme Court de Abambagbin aye eni. Me pese me bisa say de Abambagbin ye no. Emrama ne ho kwan se wo yes ana se emrama ne ho kwan Afenyo Markin mirika wo ba Supreme Court a wo ba besere no. But I say at the end of the day no, Chief Justice not otena case ni so. No yeah, I mean obviously the Chief Justice on the case no. Emum eba be ma ruling na when tie Abambagbin side of the issue. Now so no wa ma ruling e wo case ni so. Meanwhile Afenyo Markin eba no. Enye de na wo pe no. It does say our claim is substantiated by the ruling of Afenyo versus Speaker of Parliament and Attorney General, writ number J1/02/2025, dated 12 November 2024, in which the court stated that, notably, the first defendant filed no processes in answer to this action. Our understanding is that at the time of ruling on the above suit, the court had no affidavit from the Speaker of Parliament, being the first defendant. The court also stated that, however, a further step taken 2 days after the issuance of this writ, the first defendant issued a statement captured in the official report on parliamentary debates of October 17, 2024. In the first 10 pages of the official report, the first defendant elaborately delivered a response to a statement made by the Honorable Minority Leader in which he recognized that he was making a formal response in relation to a matter of significant parliament and constitutional importance. It said that he had been called on to follow precedent and declare vacant the seats of 4 members of Parliament pursuant to Article 97(1)(g) and (h) of the Constitution, because certain members of Parliament had taken actions that contravened the provision of Article 97(1)(g) and Article 97(1)(h). The above statement by the court confirms our claim that the court had no affidavit from the first defendant before ruling on the matter. Into I say based on natural justice, and you see, some natural justice argument is the same argument the Chief Justice made when the Chief Justice heard that His Excellency John Dramani Mahama receive petitions a wopese oyino. Mu kind of response na what the buy na waka say, oh, natural justice. Ma mi hu nsem ankrofo ne ka fa me ho no na mi hu ana me nso ma respond natural justice. Inti ni prako we asem a wo kan say. Natural justice, Chief Justice, odi asem no. Sa time no wontie Abambagbin side. No ma Abambagbin side emba meye omo case e wo court ho. Abambagbin was the first defendant. No wontie wo mo asem na so the ruling e by etia Abambagbin. Naturally say Chief Justice no when you sue natural justice and find ejuma. And to say our opinion is further substantiated by another statement by the court in the same ruling that both the plaintiff and second defendant filed their statement of case, which in essence aligned with the relief sought by the plaintiff in the writs. With reference to the above statement, there was no legal arguments made by the first defendant during court proceedings pursuant to the ruling. So the first defendant filed an application on the same writ on 30th October 2024. In his application, he stated that the Supreme Court breached the rules of natural justice and rule describing the manner for exercising discretion in the orders made on 18th October 2024. In hearing the application ex parte and granting orders to stay execution of the Speaker's ruling pending the resolution of this suit. Also, interestingly, the court ruled that it is very basic and primary principle of law that an order of stay of execution must be made on consideration of exceptional circumstances that can affect the parties, which exceptional circumstances include the wreaking of irreparable harm if any order of stay of execution is not granted. Also, regarding the court's ruling on the first defendant's application, the court admitted that the order of stay of execution were granted without hearing the Speaker of Parliament. The court premised the reasons behind the ruling on exceptional circumstances that can affect the parties, and exceptional circumstances include the wreaking of irreparable harm. Into asɛm what can I say? Yes, court na in the judgment no ɔtrɛ sɛ indeed ruling a wɔmaa yɛ a wɔbɔɔ Abambagbe n'asɛm gu yɛ no wentie Abambagbe n'asɛm ansa meanwhile na nka wɔsɛ otie Abambagbe n'asɛm, but reason a court no ɛmaa yɛ ɛne sɛ edu emra a yɛhu ne sɛ bɔne bi bɛto ɔman na ɛno no eni kwan sɛ bia yɛtie nipa koro n'asɛm ɛwɔ sɛ yɛ take decision nti the reason why a yɛntie Abambagbe n'asɛm still yɛdi asɛm no tie a ɔno ɛne sɛ ne yɛhu ne sɛ deɛ na ɛkɔ so no ɛyɛ bɔne bi a ɛbɛsɛe ɔman no nti nkrɔfo wei a capture no ɛtrɛ sɛ we are of the view that the speaker's decision does not meet the threshold of irreparable harm upon which orders of stay of execution are granted by the court without hearing him. So I say so what can say Abambagbe decision I will take here no na kebe bo man na oboa bibie ni wasa de na Abambagbe ye ya will take decision say NDC for ababe than the majority na nkasa asem na ya asem ben na be bo man no ankasa asem na ya asem bi e be bo man no asem no bibia atrese sa asem no anko man ne mmo nti se no nti wenti Abambagbe na asem na wo be ma excuse say oh na anko man ne be point na wo take his decision ne dia oboa. Also, we hold on to that view because those members of parliament who might have been affected by the speaker's ruling could seek legal redress and reverse whatever privileges and rights denied them. Also, omo yes 4 MPC ye gi ekonya ne free omo ho no ye declare omo seat vacant no na nko omo abetumi atwa omo ho aba court aba beka say hey the Abambagbe ndi aye ni odi asem mayen nti eno no crash say na enya asem a ye beka say ebe ma oman na abo. Also, we further express our opinion on the ruling of the Speaker's application that the Chief Justice who presided over the above application breached the rules of natural justice, which has been raised to a constitutional right in Article 23 of the 1992 Constitution of Ghana. However, such a major breach by the Chief Justice, in our opinion, amounts to incompetence. Indeed, they've made their second point clear, and their second point is because of Afenyo Markin, the case, no, and how the Chief Justice dealt with the case. Mama Wati here in one of my editorials say, you see, in one of my editorials on channel na me show me nim no. Asem me kind say, sa Afenyo Markin case no, a trap a ye setting Chief Justice no na we hu eno kokoto mu. We hu. I say prominence given to hearing in court. Into another issue omo raise against the Chief Justice ne say ensem bi wo ho de a ye hwena asem no ebia eye asomesi omo nsem a ye ndi obentin mu nsem de a na ye de mirika edi nti eno na the third reason nti a Chief Justice yes yen no mind you the first reason omo aka omo about the second reason and so now they are going to the third reason you say eno hunti yen Chief Justice no. I see in the case of R versus Chancellor of the University of Cambridge, and the Court of King's Bench ruled that the University of Cambridge acted unlawfully by depriving Dr. Bentley of his degrees without giving him a chance to defend himself. The ruling continued that even God himself did not pass judgment upon Adam before he was called upon to make his defense. Again, Dr. Dateba JSC, delivering his opinion in the unanimous decision of the Supreme Court in the case of Republic versus High Court, Denu ex parte Agbeshi Ewusi third. Number 2, Nyonyo Agbowada Sri the third. Interested party, a year 2003-2004, SCGLR 907 at 924-925 stated that natural justice or procedural fairness demands not only those affected by a decision should be given prior notice and opportunity to be heard. Odi Alterum Partem rule, but also that there should be an entitlement to an unbiased decision maker, nemo judex, in causa sua and allied ideas. So basically, omo ema eye quotation omo de kamu say Bible mukra na emra na Yesu Nyankopon ebe se wo bu Adam aten no o ka se Adam omumra no mumra metie ontie wo monsem answer. That I say, so they are quoting those these are examples are etrese na ke wo say Chief Justice no otie abambagbin insem ansa na waeden we take a decision now so we ntie. I say, Chief Justice, in the delivery of justice, we therefore humbly submit that the Chief Justice, Her Ladyship Gertrude Saki Tokonu's continuous service at the office of the Chief Justice would not restore public confidence in the judiciary as a result of demonstration of incompetence and stated misbehavior, and therefore must be removed from that high office. Attached are copies of the Chief Justice's proposal to the President and Eugene Ahin's press conference, humbly and respectfully submitted. Okay, I think that we've missed some of the pages, but it is a leaked document. Oshe send your leaky documents no kana clearly no be who say a PDF file and a copy here. So but basically now I hope say you understand the issues raised and what is going on. So the first reason you see you know you say or request it say President Akufo-Addo emfa judges embra Supreme Court or no judges or pe yemfo membra Supreme Court or, and then secondly so Abambagbin case no I think that there were more issues. There were more issues just that these are so far the leaked documents are about one thing. Seminya the continuation, especially I think say what this leaked documents talked about was just about the misbehavior side, right? Okay, so I think that we have maybe I think I've seen something. Okay. So the act of incompetence no and the Afenyo Markin no, but misbehavior no and the 144. Okay, well, so I think say it makes sense. It makes sense. Once a two cases into Afenyo Markin's own and then the misbehavior the first one I hear say or Troy Emma President Akufo-Addo say, and you see that was the issue and Professor Azar or Nusurezi Eka say Yempe Chief Justice one president no ebeko back door catch president ne say appointee we may appointee we yempe. So basically no the misbehavior side no it is that, and then the incompetence side no how she dealt with the Afenyo Markin and then Abambagbin case. I'm wishing I'm even hearing say there are additional 2 petitions. There are 2 more petitions. Maybe I'll try to read the story on that for you. But let's hope and wait and see what comes out of. I mean, this is the alleged leaked way. Let's hope that the other ones will also leak, and then we know what's going on. Bakudia Matsi, and they say Nipakrono or Ghana Stock Exchange, trade on the Ghana Stock Exchange, or alleged huge issues. Sikebia or ne EcoBank for. Nanke will say EcoBank for Chiamano and Sensem. And what say Chief Justice in the Baby BB man say Sika Semno man in Sembebre. But ya say Ebimuso alleged Sami Jenfi said there's also a petition there Obi alleged a falsification of documents. Say Yadesha Chief Justice no, and all those things are serious issues. I wish and I hope say those documents will also leak so that I'll get it and read to you guys. Much your comment box ni mo say.